Hello, Long Island. This is Chiny Diaz from Island Advantage Realty, and it is my pleasure today joining my friend, attorney Christopher Garcia.
Chris Garcia from Delisle, the managing attorney. I have the privilege of having my friend Ed Hansen as a guest speaker today. He's been in business since 1985. I've known him and worked with him for over 20 years. He handles all the landlord, tenant, and eviction cases at Delisle. He has over 10,000 cases underneath his belt.
Hi, my name's Ed Hansen. I am an attorney with Delisle, practicing mainly in landlord and tenant law, which I've been doing since 1985. I'm going to gear this mostly towards landlords. The first thing I do when I get contacted by a landlord is I email them my retainer agreement. I do so we get off on the right foot. Contains a lot of information that's helpful. The first thing it does in bold letters is tell them to read paragraph 8. What paragraph 8 tells them is if I give a termination notice and they accept rent after the termination date, they voided the notice and we have to start all over again. It also asks them whether or not the tenant is getting rent assistance, because if the tenant is getting rent assistance, whether from social services or Section 8, any notice I give to the tenant has to go to the agency. So I need to know that up front. I try to explain to them time is money. They should start the action as soon as possible. I think the biggest mistake landlords make is waiting till a tenant gets too far ahead of them. If you go after them when they owe a month or two, it's cheaper for them to pay you than it is to move. If you let someone get 6 or 7 months ahead of you, maybe it's cheaper for them to move than pay you. I also give them this analogy. When they come to me, they're bleeding. They're probably not getting the blood they lost back. They just want to stop the bleeding as soon as possible. If they can keep that in their mind, it's very helpful. In 2019, the legislature decided there was a housing crisis. So they changed all the laws relating to residential cases, all in favor of the tenant. Then in March of 2020, COVID hit, the world changed, there was a COVID moratorium, courts closed. So landlords had rough the last couple of years. Because of that, a lot of them decided they don't want to be landlords in New York anymore, they sold. Or if they were willing to still be a landlord, they raised their rent. So the law changes had the opposite effect. There's an even worse shortage now than there was before they decided to change the laws, at least in my opinion. Landlord-tenant cases are actually called summary proceedings. They're supposed to be expedited hearings. Landlord and tenant court is a court of very limited jurisdiction. It's not there to decide title. It's not there to decide property damage. Believe it or not, it cannot even determine whether or not the landlord can keep the security deposit. It's either there to get your rent or your place back. Court of very limited jurisdiction. There's two kinds of cases: a non-payment, which means the tenant's not paying. A non-payment can always be cured by payment. So it may not be the best alternative for a landlord. For instance, if the landlord's trying to sell a property, they shouldn't do a non-payment because the person pays, they stay. Or let's say the landlord has changed a one-family house into something other than a one-family house and has been caught by the town. Again, the non-payment doesn't work because he has to get the tenant out to restore the place to a one-family. The other kind of case is a holdover. A holdover means the landlord wants to end the relationship whether or not the tenant wants to pay. Maybe they are selling the house, but for every reason they want to end the relationship. A holdover also could be brought by a non-tenant. Now, landlord and tenant court actually does handle cases where there's no landlord and tenant relationship. Most common example would be a post-foreclosure. Let's say someone buys a house through foreclosure and it's occupied. They still have to go through landlord and tenant court to get them out, even though it's not their tenant. Or let's say someone's a licensee. A licensee would be someone who never paid rent, was there out of the kindness of the landlord's heart. Best example, one of my friends is down on his luck. I say he can stay in my basement for a little while. He stays there a little too long. My wife says either he goes or I go. I give him a notice, all right? That would be a licensee. Or a squatter. A squatter, now landlords think whenever their tenants aren't paying them, they're squatters, they're not. A squatter is someone who entered the property illegally. Best example would be someone sees a foreclosed, boarded up house, they break in the back window. and start occupying it. So they entered without permission. That's a squatter. A squatter is basically a criminal. To go back to the post-foreclosure, which really is the bulk of my practice, I predominantly represent investors. If they buy from a referee, they get a referee's deed at the auction, they can give a 10-day notice. Unless the occupant is a bona fide tenant. My opinion, there really aren't too many bona fide tenants. A bona fide tenant is someone who's actually paying rent to the person who lost the house in foreclosure. There's not too many of those. So many notices go to the house that as soon as the tenant realizes the owner's losing the house, they stop paying rent, and now they're not a bona fide tenant. So there's not many of those around. I do not go to the boroughs anymore. I'm getting old, I'm spoiled, so I will only go to Nassau and Suffolk. The difference is in Suffolk, every town has their own court. You know, so if it's town of Babylon, you gotta go to Babylon court. Suffolk courts do landlord and tenant 1 day a week. And you have to go to where the landlord pays his real estate taxes, to that town. There's also justice courts out east in like Riverhead and Southampton. Nassau is different. All the Nassau cases are done in Hempstead. So Hempstead does all in Nassau, and they do it 5 days a week. Very important also when I talk to the owner, they need to give me as many names as possible. We can always name John and Jane Does, but a new trick these days, and these tenants are always coming up with something, is if I name a John Doe and the sheriff goes and gives the 14-day notice and they go to court and give their real name, now I have to go and get an amended warrant, and they just bought himself like another 2 months. So it's very important to give me as many names as possible. Another thing, and sometimes, you know, purchasers of foreclosed property don't know the people's name. You know, to buy an occupied house, they have no idea who's in there. They have to at least get me one whole name, even if, you know the name Jason Doe and he doesn't show up, the sheriffs can't evict. Jason Doe doesn't exist. So I at least need one whole name, but as many as you can give me is helpful. Of course, we avoid the problem later. Difference between Suffolk and Nassau sheriffs. In Suffolk, the sheriff charges to take the stuff out of the house and put it to the curb. Nassau, they actually come, take it out of the house, load it on a truck, take it to a storage facility for a month. So it's way more expensive because you're paying them to take it out of the house, load the truck, unload the truck. Sheriffs do not just come and blindside the tenants. When they're finally ready to do it, they come there and give them a 14-day notice. Then they come back. When they come back after the 14 days, they don't give them notice, but they do give them notice for the 14 days. So at least they get a little heads up. And unfortunately, when they get that 14-day notice, that's when they go file bankruptcy or go.
Exactly.
You know, so I kind of wish they didn't.
That's when they get creative.
I wish they didn't get a 14-day notice, but they do.
Yeah.
Tenants always ask me, why should I settle the case? Well, we'll go back to what I said before, right? When you come to me, you're bleeding. So you want to stop the bleeding as soon as possible. You want to avoid a bankruptcy filing. You want to avoid a John Doe giving his real name. And time is money. So you settle the case to save time and save money. Probably talking to some realtors out there, realtors with the best of intentions. We'll try to help a landlord and maybe do the notice for him. Landlords try to do it himself, which is not a great idea. You're sick, you don't try to heal yourself.
Yes.
And even the realtors, it's nice, they're trying to help their clients, but it shouldn't be done because I see it all the time. Realtors give a 30-day notice when they should be given a 90-day notice, or they don't attach the good cause eviction. There's a new form now, it's a 10-page form. It really only applies in the boroughs. But even out here, we have to attach it to the first notice we give the tenant just to say we're in a town that hasn't adopted it. If that notice is not on there and the realtors don't have it usually, then we got to start all over again. I hate when a landlord says it's a matter of principle. I hate when they say it's personal, I want to ruin his credit. You make a practical business decision. You know, don't let it be personal. It's never about principle. You make a practical business decision, which is you want to stop the bleeding as soon as possible. Forget the blood you lost, it's gone. Now I'll take any questions you have.
So I'm very grateful for having Ed in my presence and in my career. He has come in very handy as a real estate attorney. I come across these cases quite frequently, and as you can tell
Yes.
from the many assets and comments that Ed has made, they're difficult. And I guess there's some general questions that we can ask.
Yes.
One of the questions that I think is important is, how long does the eviction process typically take start to finish?
Okay, now, it's an impossible question to answer because we don't know if they're going to file bankruptcy, but just to give you the specifics.
We don't know how creative they're
Yes,
going to
and
come
what
back.
they also do too, if it's a big family, they take turns filing bankruptcy. And they can get away with it for a while. Eventually, a bankruptcy attorney can get what's called in rem relief, which means the bankruptcy's stay is taken off and they can't file again for 6 months, so then you can complete it. But let's forget about bankruptcy. So again, there's two kinds of cases. A non-payment, you have to give a 5-day rent notice, which gets served by certified mail, and then they get a 14-day rent demand, which is served by a process server. So you have to wait 19 days before you can file a case. If we're doing a holdover, they get either a 30, 60, or 90-day notice, depending how long they've occupied the premises. Not how long the owners owned it, how long they've occupied it. If they've occupied it less than a year and they've never had a lease, they get a 30-day notice. If they've occupied it more than a year but less than 2 years, they get a 60-day notice. And if once they've occupied it 2 years or more, they get a 90-day notice. So with a holdover, we have to wait 30, 60, or 90, depending on how long they've been there. Or unless it's one of those non-tenants, they get a 10-day notice, whether it's a squatter licensee or a non-bona fide tenant. Then after that, it's the same. Getting a court date. Some of the courts are back to pre-COVID where they let me bring it in there and just wait for a court date. Some of them, like Brookhaven and Ronkonkoma, make us leave it there with an envelope and they mail it to you. Court dates take a little longer to get in Suffolk because they only do landlord and tenant 1 day a week. Nassau does it 5 days a week, so you can get a quicker date, and they do let you sit and wait for it to get the court date. Tenant has to get the notice of the court date at least 10 days before the court date, but not more than 17. We can all understand why there'd be a minimum requirement. I have no idea why you can't give them more than 17, but you can't. They have to be served in a 7-day window, at least 10 days before the court date, but not more than 17. Then you finally get your court date. Suffolk courts, you get through the court system quicker in Suffolk. Any court has to give them a 2-week adjournment if they ask for it, and they don't even have to come in. They can send in a letter. So if they ask for it, and they almost all will. If they ask for their 2-week adjournment, that's all they'll get in Suffolk. And the judge will leave a market final, which means on the next date, we either settle the case or get a trial date, and in Suffolk, the trial dates are pretty quick, 2 or 3 weeks. So you get through the court system quick in Suffolk. The Suffolk County Sheriff is not that quick. They have about a 2 to 3 month backlog from when they get your papers. Nassau will give them more than a 2-week adjournment even on the first date. They won't give you a trial date on the second date, so it takes a little longer to get through Nassau, but the Nassau County Sheriff, in my opinion, is more efficient.
That's what I heard.
So you kind of wind up in the same spot. But it could take, let's assume we have to have a trial. You'll probably get through the courts in Suffolk and get your warrant in 2 months. In Nassau, probably 3.5 months, but then you'll make it up on the sheriff's end.
Good answer.
Ed, so what documents do I need to start a eviction case in housing in New York State?
Now, I've never said this,
Basic
but I've started saying it recently. One thing I want is the deed. And the reason why in the last couple of years, I've had landlords tell me they own it in their name, and then we go to have a trial and I get their deed and they own it in an LLC. Then I have to start all over again. So I think a good idea is get me the deed, so in case they're not sure, I know exactly how they own the house. If there's a lease agreement, I need that. I need to know if there's rent assistance. I'd like to get any names possible.
Correct.
So that's a starting point.
So going back to the foreclosures, what happens when you don't have those names? Because we have a bunch of occupied properties in my office, and how can
Really not
usually the
you're not
investors,
supposed to go in their mailbox.
that's what I will do, but I know
But
I wouldn't do
maybe
something
you could ask the
not
mailman.
legal.
Maybe you could ask the mailman. If you go and then maybe the mailman can tell you who they've been mailed to. But you really have to try to get it.
Correct.
If you can't, In a foreclosure, the deed will give the foreclosed owner's name. So we always give that name, at least we have some name. And then we had John and Jane Doe's.
Yes. Okay.
That's all you can do.
So, yeah, I do have a question. A typical question is, what happens if a tenant makes a partial payment? Does that reestablish his lease?
Well, forget, we're talking about a non-payment or a holdover. I'm going to give you both.
Okay.
If you do a non-payment, your complaint is the person isn't paying you. So not only can he make partial payments, you have to accept the rent. That's the point of the case. And if he pays, he stays. But the case does not go away till he pays every penny he owes at that time. So you have to take it in a non-payment, but the case doesn't go away till he is current. In a holdover, let's just make believe I gave someone a 90-day notice today, and it expires February 28th.
Okay.
There's nothing wrong with me taking December, January, or February rent, because that comes due before February 28th. If you take March's rent, you void the 90-day notice, and we got to start all over again.
Oh, wow. Interesting.
And when I get to court, I'm allowed to ask for March's rent, but if they take it before I go to court, we got to start all over again.
So what defenses can a tenant raise that might delay or stop the eviction? Many.
Let's go for a non-payment. I like to think a holdover is non-defendable. Okay, the only defense to a holdover is if they can produce a lease or if the attorney didn't give the proper notice. That's never going to happen if I'm the attorney, so I'm not worried about that. So it's not defendable unless they can produce. So a holdover is not, or unless the landlord voids the notice by taking rent. Those are the only defenses to that. Non-payment, on the other hand, there could be defenses. A house has to be habitable. So if they don't have hot water or they have roaches running around, something that goes to health. It doesn't mean they don't have to pay a penny, but maybe then the rent's not worth $3,000 a month. It's worth $2,500 a month or whatever. So there's defenses to rent if there's something wrong with the property, and of course it could always be cured by payment.
Well, Ed, what are my rights if the tenant has unauthorized occupants on or Airbnb rentals?
If a tenant puts other people in there, we call them subtenants. You cannot get out this. The landlord has no privity with the subtenant, so they cannot get at the subtenant without going through the tenant. So if someone does put on the people, and you have to evict the tenant, and then you name everyone in the same action, but you can't go directly against the subtenant. You have to get them through the tenant.
I have an attorney question. Can I recover my attorney fees or any parts of the rent due?
Another change in 2019, which was a brutal year for landlords, is you can no longer get legal fees in a residential case. You can, all the changes were directed toward residential. So in a commercial lease, commercial property, you can get legal fees as long as it's designated additional rent in the lease. And you can also get utilities and late charges. They capped late charges in residential cases now. It has to be the lesser of $50 or 5% of the rent. It's always going to be $50. You can only take 1 month's security deposit now in residential. There's no limit on commercial. Used to be a 72-hour notice by the sheriff. Now they made it 14 days. But you can't get legal fees in residential.
In residential. So Ed, how can landlords protect themselves from claims of retaliation of discriminations?
Well, discrimination, I think you know it when you see it. But if retaliation is supposed to, they put something about that in 2019 too. But what it's supposed to be is if a tenant's complaining that they don't have heat, and then the landlord gives them a notice of termination within a year of them claiming they don't have heat, that was presumptively retaliation. But if the landlord gets caught for making a one-family house into a hotel, and he has to get rid of them because he got the town on his back, that's not retaliation. He has no choice.
Yes. And can you mention some alternatives to avoid court in this?
The only thing you can do to avoid court, and a lot of my investors try it first, is you do cash for keys. you make it worth their while to leave. You offer them money to leave, to avoid the court process and avoid the sheriff. In my experience, they'll take that way more seriously if we start the process. So my advice is always going to be start the process. I think the biggest mistake people do is wait a while before they start the process because, again, it's just more blood you lose.
My last question is, what happens if you go through the court process, the judge says you got to leave, but no one leaves the house? What's our next step there?
Well, that every case ends, whether through trial or stipulation, with a warrant being issued. It used to be, before COVID, if we had a warrant in Suffolk that, say, could be used February 28th, they wouldn't take it till a couple of days before February 28th. Ever since COVID now, they'll let you get there and get on their pile. And as you mentioned before, the pile's like 2 or 3 months high. So it's always good to get the warrant there as soon as possible. It can always be canceled before the eviction. You get most of the deposit back. But again, time is money. You have to get the warrant to the sheriff, get on their pile. It could always be canceled and you get a refund. But you have to get the warrant to the sheriff. You don't, I always say this too, hope's not an option. You don't sit there hoping the tenant's going to abide by the stipulation he signed, just like a lease is a contract too. They violate that all the time. So stipulation of settlement is just another contract. If someone signs something that they're going to get out February 28th, I don't wait till then to find out they didn't get out. I get the warrant to the sheriff as soon as I get it, just to get on the pile. It'll always be canceled.
Does the sheriff actually go with the warrant and say you're out?
They go and put the 14-day notice on the door, and then they come back. In Suffolk, they'll move the stuff to the curb. In Nassau, they load it on a truck, and it costs way more in Nassau because of that.
That's horrible.
And can you mention some cases where the evictions are delayed? Like usually what?
I'll give you one today. I had someone that was getting evicted in Nassau. One of my best clients had someone getting evicted this morning. The sheriffs got there at 9 o'clock. They had half of the house on the truck, and then they came with a bankruptcy filing. As soon as they filed bankruptcy, there's something called an automatic stay. It's hands off. Everything had to stop. They actually had to put the stuff back in the house. So now my client's going to get to pay him twice, and then you have to get a bankruptcy attorney, which I am not, to go get the stay lifted, and then you can proceed again. So it buys them 2 months. And if it's a big family, it may not be the only bankruptcy.
Yes. So what happens to my belongings if the marshal executes the evictions?
In Suffolk, they're going to be out at the curb, and if they're out there too long, they may disappear. In Nassau, they're at least taken to a storage facility.
And can the eviction appear on my record or affect future applications or credit?
Well, first of all, another change in 2019 is a landlord's not allowed to not rent to somebody because they found out they were evicted in the past. But it can definitely be found out somewhere like Fairfield or Heatherwood. They'll definitely find it. A regular landlord, maybe not. But it is you can find that a case. You just go to. If you know where the person was, what town, you can go to that town and see if there was ever a case filed against them. It's definitely findable.
Awesome.
And any new laws that just come out? You've mentioned a couple of them, but anything that...
The newest one is this good cause eviction. Now, it's really in the boroughs. Where it applies, which is the boroughs, landlord is not allowed to evict someone unless they have a good cause, unless they're a small landlord. If someone has less than 10 properties, it doesn't apply to them even in the boroughs. Out here, it doesn't apply. It doesn't apply in Nassau and Suffolk. We still have to attach this 10-page form to say it doesn't apply. It's just more expense with the prop server and mailings, but it doesn't apply here. But if that is not, even though it doesn't apply, if it's not attached to the first notice they get, it's defective. You got to start all over. And I've had a few realtors lately who tried to help the person out, and God bless them.
Yes.
But they didn't attach that form, and all they did was waste a couple of months, and time is money.
Yes. So I always like to let the attorneys to handle the situation. Some cases we put a house on the market, and we have a tenant that we can talk to, and coming to an agreement where they allow me to show the house with no problem. Chris usually send that 30 days, I don't know, it depends, notice, and they start looking rent and everything is perfectly working fine. But sometimes we have cases where I have to take the house off the market because they don't want to let me show the house, they don't want to let the seller sell the house, so we don't want this happens. I know, so most of the time, like, good communication, it's better for everybody, but when we cannot deal with these cases, of course, we always recommend you call Christopher Garcia and Ed Hansen to handle this situation properly.
The only thing I would say, and again, it's because the housing shortage has become worse. Even if a tenant has the best of intentions, and most of them do not, as you can tell them, all the landlords, but even if they have the best intentions, they might even have a place lined up. It falls through. Okay, there's someone offers more money. I mean, so it's tough right now for people to relocate. So even if they have the best intentions, you have to start. You have to give the notice. What my retainer says is, I take a $1,500 deposit from them. If the people obey the first notice, the 30, 60, 90, the rent demand, and we don't go to court, I charge them $600 and whatever the process service, why wouldn't you start? It doesn't make any sense. Considering time is money and blood's pouring out of them, they have to start the process.
Correct. So I'll say in Spanish.
You always,
Spanish?
you just blame me. Would I tell the realtor, just say my attorney made me give the notice. Just blame me, I don't care. But just say my attorney said I have to give the notice.
Of course.
We're gonna try to work with you, but we have to give you the notice. We have to start the process.
I take practice in practicing buying and selling, and so does Ed. But I can tell you that landlord-tenant law and evictions have quite a few amount of rules and regulations. And I look forward to working with Ed, and I ask him all the questions that I don't expect to know. I'll handle buying and selling. When it comes to evictions, I strongly recommend you give Ed a call. He will guide you. He will guide your client to make sure that he gets compensated, if that's what it is, and move the process along in a timely, fashionable way.
It is always worth it, and you take away a lot of headaches and a lot of economic problems.
There's a lot of delay in the system to begin with, so there's no sense in delaying the start.
Exactly.
The only thing the landlord can really control is the start, for the most part. So why drag your feet? It just doesn't make, it's not good business sense.
So like I've said in the past about teamwork, a great realtor, a great loan officer, a great attorney, now a great landlord-tenant attorney who also knows about real estate. He's on my team and I value him, and I strongly think you should make him part of your team.